Hello and welcome to episode 2 of The Legal Scoop, a webinar series where we discuss the firm's recent wins. I'm an associate attorney with the law offices of Melissa Day, and joining me today is someone who needs no introduction, Melissa Day. Welcome.
Hi, thanks for having me.
Absolutely. So today we're going to be talking about a recent win you had with the smoke break rule, correct?
Correct. So we had an employee who was out on one of her two 15-minute paid breaks. She also had an unpaid 30-minute lunch break. And she would go for walks while on her paid breaks. And during the course of her walk, she fell and injured herself.
Okay, so, and just to get a little bit into just the basic legal standard, my understanding, and it's called the smoke break rule, but it doesn't only pertain to smoke breaks, but basically if someone has a short 15-minute paid break, they get injured, 9 times out of 10 it's going to be compensable. Is that correct?
That's correct. So the standard is that accidents that occur during an employee's short breaks, such as coffee breaks, are considered to be so closely related to the performance of the job that they do not constitute an interruption in the employment. So, of course, a paid break arises in the course of the employment because it's paid. The question is whether or not it arises out of the course of the employment. And what one of the standards for analyzing these types of cases is held is that if it's a short break, that it doesn't break the chain of the accident occurring out of the course of the employment, in addition to causing in the course of the employment, even though it doesn't really happen as a result of the employee performing their job duties.
And my understanding too is that there's an emphasis on control over the employee. So like a distinction would be that a lunch break typically would not be a compensable claim if someone gets injured during a lunch break, unless say it's a work lunch or something like that.
Correct. So the rationale behind the smoke break rule or coffee break rule is that the employer retains constructive control over the employee during a short, abbreviated break, and so therefore any injury that occurs remains compensable.
Right. And there are some exceptions. So I know one of the exceptions is that if you're engaged in a purely personal pursuit. Now, what does that mean? I mean, that's kind of the type of thing we litigate, but that's one of the main distinctions, and there's some further ones that can be
Sure. So
made.
if you think of it as constructive control, the employer wouldn't have control over an activity that's characterized as purely personal.
Right.
And so the way to defeat these claims are to show that the employer doesn't have constructive control over the employee and to show that the activity is purely personal.
Okay. So bringing that all together, coming into your case, what were some of the legal distinctions that were made to differentiate this from just the run-of-the-mill, this person was on a break, they got injured, it's compensable because they were under constructive control, and this was just one of those cases where it's considered to be still working in the scope and course of employment?
Well, in addition to developing facts which highlighted the personal nature of the employee's activity while she was out on her paid break, which was the walking, she did it for exercising. I would also note that it was important in this case that we also developed the Husted exception or rule, which relieves an employer of compensability when an accident occurs outside what's characterized as the gray zone, which is that area near the employee's premise or the employer's premises, which essentially exposes the worker to a risk of the employment.
Right. And I think it helps to explain for the viewers that a lot of times that distinction is based on whether the employee is exposed to a special hazard. So I know in case law research that I've done, one of the kind of easiest examples for me to understand was a mall employee got hurt walking into work. And if she had been walking in the lobby where any customer would be walking, the general public's exposed to that risk. It wouldn't have been compensable. But when she crossed into the area that's only accessible by employees, even though she hadn't punched into work for the day, it was compensable because at that time she became exposed to a special hazard.
Right. So in addition to developing facts which demonstrated that the activity in which the employee was engaged was purely personal. So we emphasized the fact that this was and she went out for walks on her break to get exercise. There was no constructive control by her employer while she was out on these walks. In other words, they didn't tell her where she could go when she went out for a walk. They didn't tell her what kind of footwear she could wear when she went out for a walk. They didn't tell her that she couldn't use earbuds while she was out on her walk. So in addition to highlighting the lack of constructive control, the purely personal nature of the activity, which was that she was doing this activity for exercise, we also had to emphasize that the accident occurred on a location where the risk to the claimant was exactly the same as the risk to the general public.
Mm-hmm.
So it did not occur in that gray zone. It was not close enough to the employer's premises to have exposed her to a special risk of her employment. And so those factors then all taken together led to it not being compensable.
Wow. Well, I think that's really interesting. And I think just like our episode last month involving the Blue decision, it sort of shows that just because, there's sort of an area in the comp law with case law and whatnot that seems like, oh, well, this is definitely compensable because there was an accident during a break. That we're able to sometimes look into things a little bit closer, do some case law research, and build a distinction that either didn't exist or that is only developing in the board panel case law. So congratulations.
Thank you. Absolutely. The fact that this employee was injured on a paid break at first blush might lead somebody to think that the case was going to be compensable. However, we dug into the issue. I found a board panel decision, which was the employer is Montefiore. The board number is 00520247, which fit our fact pattern almost perfectly. In that case, the employee was injured on a paid break while walking to her home. During her paid break, fell across the street from her employer on a crack in the sidewalk. And the board went through the analysis that we just discussed regarding the purely personal nature of her activity, the lack of constructive control by the employer over the employee at the time of the accident, and the fact that the employee was injured on a location to which the risks were exactly the same as of the general public to what the employee experienced. So it was the right result.
Yeah, absolutely. So again, congratulations on your win.
Thanks.
We'll be back same time next month with more firm wins. So stay tuned. Thank you.
Thanks for having me, Brendan.
Thanks.